Welcome back to our final session of the 5th Belt and Road Conference. We're now going to talk about how do we deal with currency, payment issues, and digital assets in negotiating and enforcing contracts. Some people have their new digital identity and persona, which they use to interact and conduct business in the cyber world. The panel will discuss the practical issues faced by professionals around the world in dealing with cryptocurrency and payment issues and digital assets in negotiating and enforcing contracts. May we now invite the moderator, Mr. Roden Tong, Vice President of the Law Society of Hong Kong. Roden, please. Please may we also invite our honorable guests, the Senior Legal Officer at the International Institute for the Unification of Private Law of UNIDROIT, Mr. William Bridie Watson. We also have with us the Undersecretary for Financial Services and Treasury, the Government of the Hong Kong Special Administrative Region of the People's Republic of China, Mr. Joseph Chan Ho Yim, JP. We have the Law Officer, International Law of the Department of Justice, the Government of the Hong Kong Special Administrative Region of the People's Republic of China, Dr. James Ding. And lastly, we have the General Counsel of Finance, Mr. Han Ng. Thank you.
Thank you, Hian. President, ladies and gentlemen, distinguished guests, fellow members. So here we come to our final session of the day. So last but certainly not least, this session will look into a very practical topic on how to deal with currency, payment issues, and digital assets in negotiating and enforcing contracts. What are the practical issues faced by professionals around the world? So today, we have a very strong panel actually with us. So we have a distinguished speaker from Department of Justice. We have a distinguished speaker from the government, and also a speaker from an international organization, and also from a private sector. So stay tuned on hear what they are going to share with us. So without further ado, may I first introduce Dr. James Ding. Dr. James Ding is the Law Officer, International Law of the Department of Justice, the Government of Hong Kong Special Administrative Region. He has the International Law Division and reports to the Secretary for Justice on issues of international law and international legal cooperation. Dr. Ding is also currently the chair of APEC Economic Committee. He taught law on a part-time basis from 1998 to 1999 and has published on different subjects of international law and international cooperation. He has been awarded with the Chief Executive's Commendation for Government Public Service in 2021. So please join me in welcoming Dr. Ding to give his first speech. Dr. Ding.
Thank you, Roden. Good afternoon. I would like to thank the Law Society of Hong Kong for organizing the 5th Belt and Road Conference, focusing on legal issues surrounding technological developments under the Belt and Road Initiative, BRI, and also for inviting me to join these very important panel sessions. As we have heard from our earlier sessions, technological innovations have transformed the global economies and brought new opportunities. At the same time, the BRI has promoted cross-border trade, including trade in digital assets. Inevitably, legal practitioners will be faced with local legal and practical issues when advising their clients on cross-border transactions involving digital assets. I would like to share with you today some of the recent international developments with reference to the ongoing work by various regional and international organizations. First of all, let's start with the concept of data and digital assets. In its ongoing work on a taxonomy of emergency technologies, United Nations Commission on International Trade Law, UNCITRAL, has defined the data as representations of information in electronic form. Given the various forms of contracts dealing with data, Unsichild has attempted to draw a distinction between two types of data contracts, namely data provision contracts, which involve a person providing data to another person for the other persons to use or otherwise process, and data processing contracts, which involve a person processing data for another person and providing the processed data to the other person. A closely related concept to data is digital assets. The International Institute for the Unification of Private Non-Unit Draft has defined digital assets as an electronic record which is capable of being subject to control in the draft principles being developed under the unit draft's digital assets and private law projects. We have a distinguished speakers from unit drafts with us on this panel, so I will not need to further elaborate. I will just defer to his explanations later. For Unsichild, it considers digital assets to be a collection of the data stored electronically that's of use or valued. Unsichild highlighted two types of digital assets in his work. One is digital assets that represent intrinsic value owing to the rules of the systems in which they exist, sometimes referred to as payments token, for example, cryptocurrency. The other type of digital assets is those that represent value owing to their connection to some real-world tangible or intangible assets, such as goods or waste in goods, receivable and otherwise, which connections is established by the rules of systems in which they exist. A common form of such digital assets is asset-backed tokens. The unique characteristics of data, digital assets, and the digital world have prompted us to ponder on adequacy of our laws, such as contract law, property law, and private intellectual law, in dealing with data, digital assets, and other emerging concepts in the digital world. Just to name a few key challenges that we may face. While Unsichild and Unsichild have started working on the terms, there's still no universally agreed definitions or characterizations of data and digital assets. This may lead to legal uncertainty, particularly in cross-border transactions, as legal issues and principles may vary across different types of digital assets in different jurisdictions. Another challenge is that the digital economies involve emerging, rapidly evolving technology. Hence, our laws may not be able to keep up with the constantly changing landscape and advancement in technology. Data and digital assets are intangible and non-rival in nature, meaning that the same data can be used simultaneously or over time without exhaustions. Our existing law on sale of goods and property law may not be easily applicable in such cases. Transactions may occur without a physical location. Apart from the difficulty in characterizing such transactions, there also may be difficulties in determining the applicable law given the absence of a physical locations. When we come to enforcement, pseudonymity or anonymity of users in the digital world and the decentralized natures of digital economies may also pose further difficulties in identifying the parties involved and enforcing the rights. All these uncertainties in applicable legal rules undermine predictability and present many challenges to lawyers. In the Digital Economy Report 2021 of the United Nations Conference on Trade and Development, UNTAC, there are some useful observations on tackling some of these challenges. In view of the characteristics of the data, UNTAC looked at data need to be treated differently from conventional goods and services. Rather than trying to determine who owns the data, what matters is who has the right to access, control, and use the data. Legal practitioners should take particular cautions in advising on the rights to access, control, and use the data, which are core parts of contracts involving data and digital assets. The borderless and openness of the digital space has blurred the line of territorial boundaries. Data can be better understood as shared rather than as traded or exchanged. Approaches applied to international trade cannot be easily applied to data. The general and practical observations by UNTAC are useful, but we also need to find more concrete and specific means to deal with the challenges. In these connections, the UNCITRAL has been developing a taxonomy of emerging technologies and their applications covering the following areas: artificial intelligence, distributed ledger systems, smart contracts, digital assets, data transactions, online platforms, and dispute resolutions. In UNCITRAL's work, it has emphasized on technology, neutrality, party autonomy, and transparency. For data transactions, there are also discussions of whether the United Nations Convention on Contracts for the International Sale of Goods, CSG, may be applicable to data provisions contract or serve as a possible source of inspiration for future work on data provision contract. It has been suggested that the notes on the main issues of cloud computing contracts of UNCITRAL may be helpful in dealing with some legal issues arising from data processing contracts. For digital assets, UNCITRAL is considering the relevance of the foreign tax to digital assets, the model law on electronic transferable records, the model law on electronic commerce, the CSG, and UNCITRAL model law on insolvency. Earlier, I mentioned CSG. As you may be aware, CSG will become applicable to Hong Kong with effect from the 1st of December this year. The Sales of Goods United Nations Conventions Ordinance will come into operations on the same date. In the context of digital economies, as observed in UNCITRAL's work so far, there are a number of issues for considerations when considering whether CSG may be applied. Are data or digital assets regarded as goods? Are data or digital assets contracts of sale? Does payments of cryptocurrencies constitute payments of the price? Are provisions of the CSG appropriate for transactions involving data or digital assets? Can the provisions be suitably adapted? There may not be clear answer to all these questions. Legal practitioners should consider the above issues when advising their clients in specific cases. In addition to the above, UNCITRAL also closely collaborates with UNIDROIT on the project of digital assets and private law. UNIDROIT is studying and working on future legal instruments containing principles and legislative guidance in the area of private law and digital assets. The principles include the subject of private intellectual law issues, control, transfer, custody, security transactions, enforcement, and insolvency, etc. I'm sure you'll hear more from Will later on. The Hague Conference on Private Intellectual Law, HCCH, is also examining the issues of private intellectual law which are relevant to the digital economies. In particular, their work on the following areas may be of particular relevance: jurisdictions and choice of court, applicable law and choice of law, recognition and enforcement, and cross-border and cross-platform cooperation mechanisms. Practitioners may wish to keep abreast of HCCH work, which may be useful for advising clients on cross-border transactions involving data and digital assets. Apart from the work of the three sisters organizations that I just mentioned, I would also like to introduce some relevant initiatives of regional organizations such as the Asia Pacific Economic Cooperation's APEC. In 2018, the Digital Economy Steering Group under APEC was established to facilitate the development of the Internet and digital economies, including e-commerce and digital trade, guided by the Internet and Digital Economy Roadmap. The roadmap is a framework that provides guidance on key areas and actions to facilitate technological and policy exchanges among member economies and to promote innovative, inclusive, and sustainable growth, as well as to bridge digital divide in the APEC region. The focus area of work as set out in the roadmap include development of holistic government policy framework for the Internet and digital economy, promoting coherence and cooperation of regulatory approaches affecting the Internet and digital economy, enhancing trust and security in the use of information and communication technology, facilitating the free flow of information and data for the development of the Internet and digital economies, while respecting applicable domestic laws and regulations, and facilitations of e-commerce and advancing cooperation on digital trade. One of the concrete deliverables by APEC in respect in response to digital economy is the APEC collaborative framework for online dispute resolutions of cross-border business-to-business disputes, which has also been mentioned by our Secretary for Justice this morning. The framework has been launched this year with a list of ODL service providers from APEC economies, including EBAM Center from Hong Kong, China. As recognized by the United Nations, online dispute resolutions can assist parties in resolving the disputes in a simple, fast, flexible, and secure manner without the need for physical presence at a meeting or hearing. Utilizing modern technologies, ODL provides the means for resolving cross-border disputes in an expeditious, convenient, cost-effective, and secure manner. ODL may be good options for dispute resolutions in the context of data transactions or digital assets transactions. Petitioners may consider advising their clients to use ODL as a possible means for resolving such disputes. Talking about ODL, I should also mention the Asian African Legal Consultative Organizations, ALCO Hong Kong Regional Arbitration Center, which was opened in May this year. The center also offers ODL platforms and technology for handling disputes, including those involving digital assets. In fact, ALCO is also working on various areas of international law relevant to the digital world. For example, it has established a working group on international law in cyberspace. Petitioner may wish to keep track of its work by reference to the relevant report accessible on the website of ALCO. As you can see in my presentations above, there's no ready answer to the questions surrounding digital assets. Various international organizations are continuing their work in the relevant areas. Petitioners may wish to keep abreast of their ongoing work and may also exchange views and participate in discussions at the relevant forums or events, including at our conference today. That concludes my presentations. Thank you very much.
Thank you, Dr. Ding, for your latest legislation and also the digital economy roadmap sharing. So here we come that we would like to invite someone, distinguished speaker from the international organization, Mr. William Ryder Watson. Mr. Watson is the Senior Legal Officer of the International Institute for the Unification of Private Law. He specialized in secure transactions law and private international law, and lectures on international security transaction law at the Iteros Nobel Faculty of Law in Budapest. At the Institute, he is responsible for the implementation of the mining, agriculture, and construction to the 2001 Cape Town Convention on International Interests in Mobile Equipment and the development of a model law on factoring. He also serves as the Institute's liaison with the Asia-Pacific Economic Cooperation Forum and as manager of the scholarship and the internship programs. So please join me in welcoming Mr. Watson.
Thank you, Mr. Chair, and good afternoon, everyone. It's my pleasure to be here to speak on this last distinguished panel that's covering some extremely interesting issues. As noted in my introduction, I have a very specific role in this panel. I can't speak to regulatory issues. I can't speak to whether we should introduce digital assets or cryptocurrencies as national currencies because I'm not a regulator, nor can I speak to practical issues of using crypto assets to facilitate goods and services transactions because I've never used a crypto asset to facilitate a financial transaction along the Belt and Road Initiative. But there is some value in me speaking here in that I do have experience in the use and value of international instruments to improve legal certainty and lay a solid foundation and framework for international legal relationships and along the Belt and Road. So I'd like to spend the next 10 minutes focusing on these particular value adds that UNIDROIT has. So, as an officer of an international legislative organisation, when I approach a question like how do we deal with currency, payment issues and digital assets in negotiating and enforcing contracts, of course my answer is naturally international instruments negotiated by independent intergovernmental organisations such as UNIDROIT. That's naturally our response, but we also believe in the work we do. As outlined by James in his presentation, there are a range of instruments negotiated by the three sisters of private international law, UNIDROIT, UNCITRAL and the Hague Conference, that we believe would address many of the concerns and many of the issues raised today. So I'd like to make 3 points in my brief presentation. The first being the essential use of international instruments in relation to these issues because of the inherently international nature and use of cryptocurrencies and payment issues in cross-border trade between countries. Second, I'd like to talk about, it's more of a categorisation of some of the different instruments that James spoke of, and trying to understand the different instruments that are available and how they can be used throughout the life cycle of a relationship between different companies involved in international trade and provision of services in different countries. And then finally, I'd like to conclude with a reflection on both the use of existing instruments and new international developments, with an emphasis on the point that we don't have to reinvent the wheel and that many of the international instruments that already exist and successfully regulate international trade and commerce can, to a large extent, be used in relation to these new emerging technologies. So my first point is in relation to the essential use of international instruments. So as we all know, the BRI is a global initiative requiring cross-border transactions and therefore the need of clear conflict of law rules. Now that goes without saying. This is particularly relevant in relation to the use of digital currencies, which are inherently more cross-border than other types of currencies that have been used in the past, which were inherently tied to the country that was issuing the currency, the fiat currencies, whereas, of course, with digital currencies, they may not be issued in a particular place, they may not be issued by a government, so there are, I would posit, even greater risk, or there's greater transnational issues that arise in relation to digital assets as compared to existing fiat currencies. The other value of international instruments negotiated at intergovernmental independent organisations such as UNIDROIT is they reflect a balanced principle that reflects different approaches in common law systems, in civil law systems, and it's important to emphasise the negotiation process in relation to these instruments are often over many, many years, involving governments from around the world, experts at various levels of the private, we include the private sector in these negotiations. So what comes out at the end of this process for a treaty, which can take up to 7 or 8 years, or soft law, which takes a few less years, is that you have a balanced instrument that should be able to be utilised in different countries and in different contexts. Now, the reason I'm emphasising this is that in the absence of these international instruments, occasionally private sector associations or non-international intergovernmental organisations try to develop different codes, and these are very, very valuable in sort of guiding practice, but they can't replace the inherent value of having a properly harmonised, properly negotiated instrument that reflects a settled position between different governments who might otherwise have different ideas. And finally, the final point I'd make is that often we hear, international instruments might stifle private sector creativity or might actually be a brake on the use of emerging technology in different jurisdictions. And I would actually take the converse approach to that, in that I would suspect that if I was working for Binance or for a large cross-border company that's wanting to operate in different jurisdictions, if you have legal certainty in relation to the regulatory framework in these different countries and you're aware of the legal rules that are likely to apply to the emerging technologies that you're creating, that allows you to create solutions that can be utilised in different countries and not have to take a country-by-country approach. So I would argue that actually international instruments facilitate and assist international companies in operating internationally rather than impose some sort of brake on innovation. So this slide sets out many of the instruments that James mentioned in his first presentation. And what I tried to do in preparing this slide was sort of reorder them in terms of not by organisation, but in terms of the life cycle of legal relationships between companies. So most of the new work is going on in relation to the creation or the substantive rules in relation to these new assets. What is data? What is a digital asset? What do we mean when we say money? What do we mean when we say receivable? So these are the substantive rules that are essential, the central part. So when companies are making an international contract in relation to goods or services, they note that they're using common terms and there is a clear legal meaning for the asset that we're talking about. And as James mentioned, in relation to digital assets and data, these are ongoing works in both of these fora. There are not yet established internationally recognised definitions for these, but there should be in 12 months' time from now, so we're not too far away. In relation to contracting, there is a plethora of international instruments that already exist that address many of the issues that have been discussed today. Obviously, the UNIDROIT principles and international commercial contracts, as well as UNCITRAL's Convention on the International Sale of Goods. Most of these rules, I'll mention in my final slide, already address many of the issues that have been raised today. Perhaps they need to be reinterpreted in the light of new emerging technologies, but I would say let's not, to use a strange colloquialism, let's not throw out the baby with the bathwater. Many of these instruments can still be used, and even though they've been negotiated 20 or 30 years ago, well before the proliferation of these new technologies, over time, technology has changed many times since the PIC was first negotiated in 1994, yet they're still relevant and they're used every day in international disputes, especially in arbitration. So to say that now all of a sudden that they cannot be applied and they're no longer relevant, I think is probably a stretch. There's also particular rules in dispute and enforcement. I would highlight UNIDROIT's current work on effective enforcement across borders, which is also a work in progress, but hopefully will be finished next year. And there are, of course, regulatory issues to be addressed. They aren't handled by UNIDROIT, but there is international intergovernmental organisations working on these regulatory issues at all. So there is an international framework on these issues. It's not like we're operating in limbo. So my final point is, yes, clearly there are the necessity for some new rules, which is why they're being developed, particularly in relation to the categorisation and treatment of digital assets. So what is a digital asset? How you perfect with reference to control, the conflict of laws rules in relation to those. What is data? How do you deal with data? However, in most cases, I would argue existing international interest rates facilitating cross-border contracting, trade, border and finance are still applicable. There's no need to catch up to the technology train. We just need to reinterpret what's already out there. Because these international instruments have been negotiated using the concept of technological neutrality. It doesn't matter what how the technology emerges, these older instruments will still apply. Of course, in practice, this could be very challenging, but as I've mentioned, over the past decades, by and large, these international instruments have still served their purpose in regulating cross-border legal relationships and the provision of finance. One particular example I can use here is in the model law on factoring, which we're currently preparing at UNIDROIT, which will be negotiated and finalised next year. We define a receivable in Article 2 as a contractual right to payment for a sum of money. And when we're addressing this issue in the Guide to Enactment, we're making it very clear that when we mean money, we don't mean fiat currencies. We mean anything that can be used as a medium of trade, and that it would absolutely apply to cryptocurrencies and other digital assets as well. So So I think we're already ensuring that the instruments we're developing now and the interpretation of past instruments address these technological issues. I think that is my 10 minutes, so thank you very much for your attention. I look forward to the discussion following the panel. Thank you.
Thank you, William. Now, another distinguished panelist with us today is Mr. Joseph Chan Ho Lim. He is the Undersecretary for Financial Service and the Treasury, the Government of the Hong Kong SAR. Mr. Chan has many years of senior executive experience in the banking industry. He was the Managing Director in the Global Markets Divisions of Credit Agricole Corporate and Investment Bank and in financial markets of Standard Chartered Bank. Prior to joining the government, Mr. Chan held multiple roles in a number of public and professional bodies, including Vice President of the Hong Kong Society of Financial Analysts, Director of Hong Kong Securities and Investment Institute, Advisor of the Chinese Gold and Silver Exchange Society, as well as a General Committee member of Hong Kong General Chamber of Commerce. So, Mr. Chan, please. Thank you.
Thank you. It's great seeing you here today, and my pleasure to have the next 10 minutes to share with you about our view on the virtual assets development or so. Well, to begin with, like what James mentioned early on, I think at the moment, universally, there's no universal agreement on the definition of digital asset per se, right? If you look at the industry, legal framework, regulatory framework, there's no universal agreement on that. And what's definition of digital assets? That could be STOs, could be stable coins, could be ICOs, could be cryptocurrency like Bitcoin, could be CBDC, central bank digital currencies, and can be NFTs, so on and so forth. And it's not only about the definition that required more understanding and regulatory framework, but also the related downstream services such as the exchanges, such as the issuer's role, such as the custodian services. And also, it involves other type of related products, financial products, such as funds, derivatives, and also the institution involved, such as intermediaries as well. So it is very, I would say the landscape is very dynamic and evolving. But one thing is certain is that if we look at the development of the DLT, and also the blockchain technology, right? It offers financial innovation, it improves cost efficiency, and also inclusiveness as well. So we reckon virtual assets business is here to stay, and is also offering opportunities related to Web 3.0 and Metaverse. And in light of this, the Hong Kong SAR government last week issued a policy statement on development of virtual assets in Hong Kong. Our vision and approach is that Hong Kong is open and inclusive towards the global community of innovators engaging in virtual asset business. We will provide a facilitating environment for promoting sustainable and responsible development of the virtual asset sector in Hong Kong. And we will also offer timely and necessary guardrails to mitigate the actual or potential risks in line with international standards as well. If we look at the policy statement, in terms of regulation, our objective, right, is to offer consistency, predictability, and clarity gradually through establishing a regulatory framework. And that will offer a solid foundation to further embrace financial innovations and technological development brought by the rapid development of the virtual assets business globally. In that policy statement, a few areas I would like to share with you about our regulations, current form and also the future direction. First is that we are setting up the new licensing regime for virtual asset service provider. for this regime, the definition of virtual asset, we are making reference to the definition under FATF, Financial Action Task Force. So the new regime will align requirements for virtual asset exchanges in terms of anti-money laundering and counter-terrorist financing, as well as investor protection as well, to those currently applicable to traditional financial institutions, hence offering licensed virtual asset exchanges the status and credibility to access a wider net of investors in the Hong Kong market. The other one about regulation is exchange traded funds, ETFs, on virtual assets in our market in Hong Kong here. So we are open to the possibility of having ETFs on virtual asset in Hong Kong, and subsequently last week, the SFC has also issued a circular on this to share with the industry our current guidelines on ETFs on virtual asset futures, and also the potential future development in terms of offering more potential virtual asset underlying for ETFs to link with and to link to in the future. The other element in our regulations is that we will do a public consultation on how retail investors may be given a suitable degree of access to virtual assets. And to be precise, the upcoming licensing regime for virtual asset service providers or virtual asset exchanges will be confined to professional investors only. But we will, through SFC, conduct a public consultation on how we can offer access to retail investors with under the new licensing regime, but given certain degree of measures to protect investor protection, particularly for the retail investors as well. And also in the statement, we touch on the regulatory regime for stablecoin. Basically, on stablecoin, our central bank or the banking regulator, HKMA, has already issued a discussion paper on this subject to seek the industry and public's feedback on putting in place a risk-based, proportionate, and agile regime for regulating activities related to payment-related stablecoins. Now, HKMA is actually studying the feedback already collected, and the consultation outcome and the next steps will be announced in due course. And the fifth point I would like to share with you from the regulation side is that we will conduct review on property rights for tokenized assets and the legality of smart contracts as well. Apart from regulations, we also want to demonstrate our commitment and also openness in exploring the technological benefits brought by virtual assets through 3 different pilot projects. One is that last week for our FinTech Week, we have issued non-fungible tokens, NFTs, for the participant of FinTech Week, so as to demonstrate our engagement with the FinTech and the Web3 community as a proof of concept project. We also announced that we will tokenize our future government green bond issuance for subscription by institutional investors that will cover us in terms of the future government green bond issuance, the life cycle, settlement, the redemption payments, so on and so forth. And also, we announced that we'll continue to push forward in terms of studying the development of eHKD, the electronic form of Hong Kong dollar, as a central bank digital currency to be applied locally here in Hong Kong. And all in all, I think our spirit for the policy statement, well, is that we are talking about the government, in conjunction with our financial regulators, are working towards to provide a facilitating environment for promoting sustainable and development of virtual asset sector in Hong Kong. And I think making reference as well to just now what William said, is technology neutral approach. So meaning that we will adopt the same activity, same risk, same regulation principle to put in place timely and necessary guardrails so that the potential risk on financial stability, consumer protection, as well as money laundering and terrorist financing risks can be mitigated and managed in line with international standards. Just now I mentioned central bank digital currency or e-Hong Kong dollar. So quickly want to share with you that we adopt a proactive and open-minded approach in terms of the issuance and application of CBDC. And in fact, in September, the HKMA already released a position paper on e-Hong Kong dollar, how we're going to move forward on that. So basically, we set out 3 rails. First is to develop the necessary technological framework and legal foundation for implementation. Second rail is to examine the actual use cases and implementation details of e-Hong Kong dollar. We will conduct both the first rail and the second rail in parallel at the same time concurrently. And after finishing these 2 rails, then we will look into the third rail, which is to set a timeline for the actual launching of e-Hong Kong dollar, taking into account the pace of the local and the international markets development on CBDC. Well, for the Belt and Road initiatives, we see that increasingly offshore renminbi has been used in terms of infrastructure financing and also trade finance as well. Well, Hong Kong, we are already the biggest offshore renminbi center in the world. We possess the biggest offshore renminbi liquidity in the world, and also we process around 75% of offshore renminbi payments at the moment. So that's why the development of ECNY, electronic renminbi, will also be very important to our role in terms of facilitating the internalization of renminbi and also facilitating the offshore renminbi flow within the Belt and Road region as well. So HKMA has been working with the Digital Currency Institute of People's Bank of China to expand the scope and scale of technical testing of using ECNY in cross-boundary payments in Hong Kong. Actually, we have completed the first phase of technological testing already. We are now in the second phase on technical testing, including the top-up of ECNY wallet through faster payment system, our own digital infrastructure in Hong Kong, and also we are inviting more participants as in banks and merchants to participate in the testing as well. We believe that the use of ECNY will offer additional means which is safe, convenient and innovative for cross-boundary retail consumption to residents in Hong Kong and mainland as well. And of course, by doing so, it will help promote the fund flow or mutual access within the Greater Bay Area and also further consolidate Hong Kong's status as the global offshore renminbi business hub. Of course, talking about the Belt and Road region, we should look beyond cross-boundary payments between Hong Kong and mainland market, but also other economies or jurisdiction in the Belt and Road region. So indeed, we are also looking into the CBDC cross-border application within the Belt and Road region as well, so that it will help facilitate capital flow for trade and investments in the region. So the HKMA is conducting the multiple CBDC bridge project in collaboration with PBOC, also the Bank of Thailand, the Central Bank of the UAE, and also the Bank for International Settlements Innovation Hub Center here in Hong Kong to explore the capabilities of distributed ledger technology, DLT, in facilitating real-time cross-border foreign exchange payment versus payment transactions. Well, we reckon the mBridge trial platform addresses the principal pain points of the current cross-border payments in international trade settlement that we always experience within our business activities within the Belt and Road region, including high cost, low speed, operational complexities, while also ensuring the policy regulatory compliance and privacy mechanisms are appropriately integrated. So we believe that definitely the development and promotion of cross-border CBDC transaction can address these issues. Well, on that, I would like to say that in terms of our overall policy statement, the fundamentals are that we are embracing the technology on terms of DLT and blockchain, but we need to use them in facilitating the real growth of our real economy. And at the same time, as I mentioned earlier on, there will be various types of risks associated. At the end of the day, we are talking about walking into uncharted water in terms of the development of virtual assets for the financial world. So it won't be straightforward. It involves considerable risk throughout the process, but we believe that by monitoring the development very closely. By putting in timely and necessary guardrails, we can facilitate responsible and sustainable development of the virtual asset business. And on that note, I'll conclude my presentation, and I look forward to the Q&A sessions on these subjects. Thank you.
Thank you, Undersecretary Mr. Joseph Chen, for sharing with us such an in-depth and comprehensive policy statement from the government. It appears that there's a lot that the Hong Kong government will do on this digital asset world. So now comes to the final panelist. So he's from private sector. Mr. Hon is also with us today. He's the General Counsel at Binance, and he leads the company's legal department and works closely with the company's compliance, government affairs, and policy and business teams to handle legal matters on blockchain and Web3 space, as well as constructively engaging regulators around the world. Prior to joining Binance, Mr. was the legal director at Uber Technologies Incorporation and an attorney with leading international law firms. So please join me in welcoming Hon.
Thank you very much. So for those who have been following what's been going on in the market, it's been a very busy 48 hours, and happy to kind of engage on the Q&A as well. But, you know, I think the last 48 hours have been quite revealing. I think it quite instructive as well. We've certainly been busy. I was up until quite early this morning trying to figure a few things out. So happy to engage in that in a moment. But as someone from Hong Kong, with parents from Hong Kong, grandparents from Hong Kong, and myself from Hong Kong, I'm actually very excited about the changes that the Hong Kong government is making in the policy space, because for me, as someone dealing with international government affairs and policy and knowing and dealing with governments very intimately, I actually think the new policy changes are extremely exciting. We're actually thrilled to see that, so thank you for taking that bold step. I do think, and I'm slightly biased, I do think it will help Hong Kong become a digital asset hub in the region and internationally. So, you know, that's credit to the government there. Let me just move to the three things I'm going to cover. This topic really excites me because, you know, we have our distinguished panelists talking about really the black letter law and how to apply it in not only the real world, but also the digital world. And I find that really exciting because, you know, it takes me back to my university days about, you know, applying case law from 100 years ago, 200 years ago. It's still relevant. And I think what's really interesting is that the more I work in this digital space, the more relevant this body of law becomes. And I wanted to cover three areas: a brief introduction to this digital space, in particular smart contracts, about the topic of how it helps the Belt and Road Initiative, and then 5 issues that I think that we need to think about in relation to smart contracts. And then finally, looking ahead about what's happening. For those who are not familiar with Binance, we are the largest crypto exchange in the world. We cover quite a lot of countries, and happy to, again, describe more about the company, but it's not really about the company, it's really about the industry here. We can see here that the market capitalization of cryptocurrency has grown. This chart only shows up to April 2022, which is just before what we call the crypto winter, which is a bit of a crash in terms of the market capitalization. So that number will have dropped. But it did top up at an all-time high of $3 trillion. While that seems very high, if you can see the trend, it is trending up. It's actually a very, very low part of the overall financial market. You can see here that we think the penetration rate is about 3.9% of adoption. But we do think that wider adoption is going to happen, particularly in Asia and Africa. If we look at how this represents in relation to bonds, stocks, gold, and also the largest market cap companies in the S&P 500, we can see that cryptocurrency is actually a very, very small part of the entire ecosystem. However, it's growing. It has a lot of space to grow. And I think this is where regulation and good law comes in, right? Because in order to grow in a safe and regulated manner, we need good regulations. We need developed laws around this space. And I think from listening to my distinguished panelists, I'm very confident that we'll get there in Hong Kong. And finally, just a final slide on the introduction. Stablecoins is quite a big topic. We, as a company, Binance actually consulted with the HKMA on stablecoins. So we were very honored to be reached out to, and we tried to give as reasonable opinions as possible to help the development of stablecoins in Hong Kong. We actually issue through Paxos, which is a regulated player in New York, the world's second largest stablecoin. It's, I think it's number 5 kind of most widely held cryptocurrency in the world. And you can see that the market cap of the entire stablecoin community is really a small percentage of the entire money flow supply around the world. So again, it's an interesting fact because there is a lot of space to grow, but we can see here the kind of context in which we're talking about here. And finally, the estimates of crypto users is around 300 million at the moment. We think that will grow, but it will take another cycle for that to grow into the mainstream. And the mainstream is really where the growth is going forward. So that's a story of kind of where we are, which is we're really at the start of this exciting financial evolution. And talking about smart contracts, which is the topic of this conversation here, I do see 5 issues that we see in the private sector in relation to this. One is, how do you enforce these smart contracts? You don't know that, typically a smart contract, for those who don't know, is a set of code. It's a code of ifs and when, and if that happens, then it's executed. But sometimes things go wrong. You can have coding errors, and you have 2 counterparties who don't feel like they've got what they bargained for. Then what happens? And I think, an important part of this is KYC and counterparty identification. At its infancy, the crypto exchange world really didn't focus on this. And in some ways, we need to take a leaf out of the banking world, right? KYC is extremely important. You cannot enforce, you cannot know what you're doing unless you know who the counterparty is. So number 1 is counterparty identification is super important. And for us, we were one of the largest exchanges that actually started to apply this worldwide. Second is cross-border disputes. So do we use the same rules or do we have new rules? This is a conflict of law question. There's obviously issues around standardization, which is what the panelists have discussed already. It is an extremely interesting area. In traditional contract law, you know who your counterparty is, you know where they sit, you have a contract, you may have a choice of law provision, you may have a court provision. In a smart contract, you don't have those things. And then if you go back to traditional legal analysis, then where is the contract executed? Where's performance? And so this is very interesting because in a digital world, sometimes you go back to where the servers are located. Where is predominantly the counterparty? If they're around the world, where do they have substance? And I think these are just super interesting questions around cross-border disputes for smart contracts that the legal world, legal community here amongst us have to deal with. Number 3 is asset freezes. Obviously, you need to enforce potentially a court order. How do you do that? For us as a company, we've actually dealt with over 27,000 law enforcement requests and helped law enforcement since 2021. Our policy is to help. So we don't have an official, sometimes we don't need an official kind of court papers. We help because we feel like we need to. And sometimes we do go through, the MLAT processes, etc., established processes in international law. But we are here to help, and I think law enforcement have appreciated that. Number 4 is data privacy, which is super interesting because there's a tension between data privacy and the notion of a right to forget. So under GDPR rules, right to forget is a core principle. But under blockchain, it's all about transparency. It's all about the information being there for everyone to see. So how do you reconcile the tension there? I think there are many ways in which to do that. There are things in which you can encrypt the data so that only the right people can see the data. It's still there, but only accessible to those who need to know, for example, governments. So I think that's an interesting tension. And finally, volatility in asset prices. You know, when you have a smart contract, there's some value there. But how do you fix that if the prices keep going up and down? So I think that's an interesting area, and this is where maybe stablecoins comes in, where CBDCs come in as well. And finally, looking ahead, I mean, supply chain efficiencies, I think, is obvious. It's really about time, resources, and friction. If people can conclude their contracts easier with less people, less resources, then it's going to result in, hopefully, reduced costs and more money to put into more useful areas, such as existing infrastructure, building new infrastructure, etc. And I think that just generally, if we can make that ecosystem happen, there'll be increased transparency and trust. Third, I realized the numbers are wrong there. Third, I think, as I said, we really welcome the Hong Kong government's recent policy announcement. I think looking ahead, that's going to be super interesting for Hong Kong, and we look forward to cooperating and collaborating with the government on their policies. So I'll leave it there and look forward to the questions during the Q&A session. Thank you very much.
Okay, it appears that there's a lot of very insightful sharing today from all the panelists. So from the private sector standpoint, and also from the government, that we have a very comprehensive policy in place going forward. So with this, perhaps I will start off to ask some of the questions. Actually, there's a question from the floor in relation to the regulation standpoint. Perhaps I will start off to ask Undersecretary Mr. Joseph about this question. So do you think that, I understand that the policy you just in place is basically to promote Hong Kong to enter into this digital world. But do you think that the regulation will stifle the creative growth on the metaverse world?
Thank you. Well, as I mentioned and also as set out in our virtual asset policy statement, we believe that the new technologies underpinning the virtual asset sector, from DLT or Web 3.0 to the metaverse, all have the potential to bring immense benefit to the financial sector and its clients. So to us, it's all about recognizing the potential of the technologies and embrace the benefits while identifying and also addressing and mitigating the risks and challenges as well. We believe that the purpose of drawing these regulations, at least in the case of Hong Kong, is therefore to provide the necessary and suitable guardrails, as I mentioned earlier on, so that these new technologies and the applications can thrive in a vibrant yet sustainable ecosystem. And in this regard, I would say that the regulations should be seen as a more complementary rather than an opposing force to innovation and creative growth. And from my experience as well, over the last few months, I have spoken with many virtual asset players or STO issuers. Actually, from their perspective, they also share with us, look, they're actually looking for regulations so that it will help induce confidence to the investors, to the customers, and to the professionals as well. And a lot of those that are serious players, actually, they want to have a regulation regime, certain criteria to distinguish between the real players who are willing to comply with the international standards in terms of KYC, anti-money laundering, counter-terrorist financing, and those who cannot do that because of the lack of scale or lack of capability, so that they welcome such a regime to help promote the sustainable and responsible growth of the sector. So I do believe that as long as we can strike the right balance when we set out this regulatory, it should be, in the long run, very beneficial to the growth of this industry. Thank you.
Thank you, Joseph. Actually, there's a follow-up question from the floor. Basically, he asks, is it possible for the Stock Exchange of Hong Kong to acquire cryptocurrency platform in order to increase the competitiveness of Hong Kong in the crypto market among the world? So what do you think about this?
Well, to begin with, I'm a policymaker, and I think this question touches on a commercial decision as well of listed companies. So I better not to make a very direct comment on that. But what I would say is that at the moment, in Hong Kong, there are over 10 virtual assets exchanges operating already. And what we're doing is, as we introduce this licensing regime, most of those told us they want to apply for the licensing regime. And with this licensing regime in place, and these over 10 exchanges continue to operate here in Hong Kong, I think we are already forming a very sustainable and healthy ecosystem in that aspect. If you ask me in the long run how the virtual assets business will evolve, or in the long run whether there will be more consolidation or so, I don't have the crystal ball here, but I can assure you that we'll continue to monitor the development of the business. And as I mentioned earlier on, we need to put up the guardrails timely. On a timely manner to facilitate the growth of the business while protecting the investors as well.
Thank you, Joseph. So, Hon, you are from the private sector. What do you think? You can speak more then.
Can you hear me? Yeah. I've never actually considered this question, actually. But perhaps I shouldn't say too much, but I mean, I don't see why not. I think that the crypto exchanges would need to organize themselves slightly more maturely in terms of kind of how they're currently set up. I think there's a few things that the industry as a whole needs to do. I'm sure stock exchanges would look into that very carefully. But, as a concept, I don't see why not. But I think it may be early days for that. I think we need to see how the sector develops, what the regulations look like before we get into that.
Okay, thank you, Hon. So let's ask a question about from an international perspective. So, William, so what if one party is subject to unsecure and unitary rules and the other isn't? So what will you do then?
Thank you for the question. So it will be a relatively rare circumstance where you had two parties to international commercial contract where you would have one subject to the principles of international commercial contracts or the CISG and one not, because in vast majority of circumstances they apply where there has been a choice of law agreement within the contract in relation to the parties to this contract agree to apply principles of international commercial contracts or the CISG. The CISG can also apply under the rules of that treaty where both the two parties to a dispute are both located in contracting states that have and both separately contracting states. So usually the issue of applicability of the principles of international commercial contracts comes up when you have a dispute and it goes before the court, and the court has to decide whether to apply the party autonomy clause in the contract and whether the choice of law rules in that forum allow the application of a non-state-based set of rules, the UNIDROIT principles, or not. And in many cases they won't. In international arbitration, it is more likely that a choice of law clause in a contract for an international commercial contractor will be upheld. I think what might be interesting quickly for me to reflect on in relation to this panel is that our ongoing work in relation to digital assets, which I emphasise is ongoing, it's not complete, but they've currently Principle 5 of the draft Principles on Digital Assets talks about conflict of law rules in relation to digital assets. And they've necessarily have to taken a fairly innovative approach given the transient, transborder nature of these assets. And currently, the Principle 5 takes a waterfall approach where the applicable law will be either A, the law, actually the choice of law set out in the digital asset itself, and that's actually encouraging, it's almost a forward-looking proposal trying to encourage the creators of these digital assets to try to enshrine that in the digital assets itself. If that doesn't apply, the second step is the law selected by the issuer or the central registry of a digital asset to the extent that exists. And if, again, 1 and 2 don't apply because there's neither of the digital asset nor the issuer has made such a selection. The third rule is essentially the conflict of law rules applicable in the forum in which the dispute has occurred. So this is quite an innovative approach, quite a new approach, and we haven't quite finished this project yet, but that's the approach that's been adopted by the international group of experts negotiating the instrument up to now.
Thanks, William. I see that very, very insightful. Thank you. So perhaps I now ask a more technical question to the Department of Justice. So, Dr. Ding, so will there be an import and export issues for digital assets that parties need to take into account?
Thank you, Walden. That's a very practical issue. I think when dealing with a case about import-export of digital assets, I think the first questions should be, as I mentioned in my presentation, characterizations of the digital assets. There must be a convergence of mind on what the parties means by the import and export of the digital assets. Because there could be different ways of categorizations. And as I just mentioned in my presentations, for a data contract, Ancestral has attempted to divide data provision contract and also data processing contracts. So there could be different types of contracts that I think the parties or the lawyer advising the parties should make a distinction of. And the other important question is about applicable law. So what should be the applicable law in such a case? And there may be some consideration about the conflict of law rules, choice of law, and also, as I mentioned, the CISG, the Conventions on International Sale of Goods. Does the convention apply in such cases? Would, in that particular case, whether the CISG applies? So these are all the relevant considerations that the parties should take into account, or the lawyers should advise them. And even if the CISG is applicable, the lawyers may also advise the clients whether, in that particular case, whether it's necessary to opt out the application of CISG, because that's permissible under CISG. So these are all different considerations that the parties should take into account.
Thank you, Dr. Ding. So as you can see that our theme this year is called Money on the Belt and Road. So I would like to refer this question to Horn. Horn, so as you can see that in the last couple of days, there's quite a big news in this metaverse market. So do you see that on this market is now for the investment is still very immature or very volatile? So how do you see it? And as an investor, what is your advice to that?
Yeah, it's obviously I can't offer any financial advice. That's just let's be clear on that. But I think what I maybe can comment on is just I think the general sentiment and maybe the direction of what's happening. Generally Roden, we spoke about it just before the session about just general technology situation and what's been happening with technology companies, predominantly from Silicon Valley. There's a bit of a consolidation going on and a bit of a pivot, let's say. And a lot of companies are figuring out how to get into the Web3 world, what that means for them. What does Web3 itself mean? What is the metaverse? I think these are just, for me, exciting questions to ponder and actually execute against. But I think we're in a very, very early stage of what that looks like. If you asked yourself maybe 20 years ago, what is the internet? You could give a reasonably educated answer maybe, but you probably wouldn't be able to imagine how it's being used today and what the future would look like. So I think it's difficult to imagine what the metaverse and Web3 will look like now. But part of the excitement is the unknown, is to build it. And I guess with the question about the market sentiment, there is, as new things develop, I think regulations will catch up, and I hope it does. That's, as a lawyer by trade as well, it's exciting to see the law evolve. And I think once that happens, you have a very good framework, a very consistent and safe framework in which to operate and generate innovation. So right now we're in the space where we're kind of in between. We'll get to a place where actually it's a little bit more settled, and that's when, hopefully more innovation will happen.
Thank you, Juan. So actually, I have a number of questions I want to ask the panelists, but in the interest of time, I must ask one question, because this is from our president, Mr. C.M. Chen. So I'm not quite sure whether the president, which panelist we want to ask, but anyway, the question is, how do we identify the originating and beneficial owner of virtual assets from regulators or service providers' viewpoints? So is any panelist, Mr. President, you want to ask? Anyone?
Thank you. So if I get the question correctly, you're talking about how to identify the ultimate owner, right, of the assets. On one hand, of course, the technology of DLT and blockchain is decentralized, right, in terms of framework. But on the other way around, as we set our regulations for the virtual asset service providers to operate here, as I mentioned earlier on, we need to apply the same activities, same risk, same regulation principle, meaning that for the moment, let's say for financial institutions, banks, securities, they are subject to KYC, know your customers. So we will require the licensed virtual asset service providers to also have the same compliance with KYC, know your customers as well. In fact, these are also requirements for anti-money laundering and counter-terrorist financing as well. And in fact, if you look at our current legislative proposal, currently under scrutiny by LESCO, the title or the name of that legislative proposal is exactly about money laundering and counter-terrorist financing. So I hope that explains to you that, okay, maybe the technology would includes an element of not showing the name of the ultimate owner or so. But I think by the proper regulations through the process or through the licensed players with KYC or the way they interact with traditional financial institutions who need to know the source of funds, then through this different aspect, eventually we could identify who are the owners subject to the KYC and the risks that I mentioned earlier on. And one last thing I want to say, since we are on this topic, is that it's actually also some sort of requirement by Financial Action Task Force under G20, so that it's not only Hong Kong working alone. As we drafted our licensing regime for the virtual assets service providers, we also make reference to the guideline published by Financial Action Task Force as well. So while we do not have a completely or universally agreed definition on digital asset per se, still I do think the regulators globally and the governments globally are working together to mitigate and address the risks that would arise from these type of activities. Thank you.
Thank you, Joseph. So I think we are now time. So on this note, may I thank all the panelists for all this insightful sharing, and I hope all the participants today can have all this insightful sharing with us. So thank you very much.
Thank you. Thank you, Mr. Tong, and thank you, esteemed panelists. Very thought-provoking conversations. May I now invite Mr. Tong to present souvenirs to our guests. I'm sure we all had a lot of very useful takeaways from all the sessions today. May we now invite Mr. Fred Khan, Chairman of the Belt and Road Conference Organizing Committee of the Law Society of Hong Kong, to share with us some closing remarks. Mr. Khan, please.
Mr. President, distinguished guests, ladies and gentlemen, it is my pleasant duty to thank the speakers at the opening ceremony, as well as all moderators and panelists for the 4 sessions. 2 on regulating the metaverse and 2 on money on the Belt and Road. These are important topics of the day. The metaverse is a virtual world that connects the physical and the digital worlds. It may be a dominant aspect of the future of mankind. Proper regulation of the metaverse may mean putting our future in proper order. At this conference, we just heard about the desirability of a metaverse convention. Hong Kong is an international city. Hong Kong is an international financial center. Hong Kong is a bridge. Hong Kong may well be in a good position to promote such a metaverse convention. Money on the Belt and Road. Money in the form of currency is a bloodline of economies. Currency and trade are intertwined. Bearing in mind the vulnerability of many economies, we have endeavored to tackle the issue of a neutral global currency, which may become pressing in a world plagued with conflicts. This has indeed been the most scintillating exploration of the topics under discussion. I have the feeling of having gone to a bountiful banquet, but strange enough, I still hunger for more. In the first Belt and Road Conference held on 12 May 2017, 39 lawyers' associations from 24 jurisdictions signed the Hong Kong Manifesto, promoting legal cooperation between lawyers from the Belt and Road regions. In the second Belt and Road Conference, held on 28 September 2018, 34 lawyers' associations signed the Law Tech Alliance, promoting a shared ethical AI framework between lawyers from the Belt and Road regions. Although no formal document is signed at this 5th Belt and Road Conference, the tradition of forging cooperation and using the conference as a springboard for international interaction and discussion on pressing issues for the future still stands firm. The Law Society of Hong Kong commits itself to this goal. The Belt and Road Conference will always be an intellectual well from which we all come to replenish ourselves. For on behalf of the organizing committee, I thank the Department of Justice for their great support, financial and otherwise, for including this conference as part of Legal Week. I also thank the Commonwealth Lawyer Association and Law Asia for being our sponsors. Before I declare the 5th Belt and Road Conference ends, I shall be remiss if I do not thank Mr. Nick Chen, the chairman of the Paper Committee, and members of his committee for coming up with such a fantastic program. I thank them and other members of the organizing committee from the bottom of my heart. I must also thank the Law Society Secretariat for its unyielding dedication and hard work. So, goodbye, good luck, good health to all of you, and see you all in person at the 6th Belt and Road Conference. Thank you.
Thank you, Mr. Khan. On behalf of the Law Society of Hong Kong, we want to say a big thank you for all of you joining here physically and virtually. We would also like to express our gratitude to the Department of Justice of the Hong Kong SAR government for the continuous support of the Law Society events. Hopefully, we'll see you all next year in our 6th Belt and Road Conference. Thank you.